requesting a temporary order today and asking the court to reserve retroactive support for another time. I have some wage information for Mr. Felton that's current, but I believe the couple separated in 2021, so would be requesting not just W-2s but tax returns going back to 2021, so we can work out the retroactive. Defer to the court in the item as far as conservatorship, possession, access. I do ask the court to make appropriate ruling as far as non-disclosure is concerned. I believe the evidence will show that Mr. Felton's current wages is making $3,205.06 a month. I believe the testimony will be that there's not insurance at reasonable cost, so would request, I believe it's 2 children in and no children outside, so 4.5%, $144 medical, and I calculate guideline child support at $650. So that's going to be the request unless I hear something else in testimony, Your Honor.
Thank you. Mr. Gobday. What are you requesting today, sir?
Okay. Your Honor, for Mr. Felton?
Yes.
Okay, thank you, Your Honor. May it please the court. We already addressed the issue of temporary orders. You already denied, we were here, I think actually close to a year ago, you denied the issue of temporary orders. We're supposed to be going for finance. If the AG needs document from both parties, he can request it and they can provide it, but
Here's no, sir. They were originally served with that documentation as far as their request for production. The original pleadings in this case had the request for production for W-2s, bank records, all that was included, and that's what they were served with. But go ahead. Go right ahead.
I understand. Your Honor, we've made opening before. The parties have been doing, 1 week on, 1 week off, even now, before they met us. And that's what my client requested. The judge has the power to adjust child support based on what they're doing. If mom is only asking for just to spoil everything they're doing because of child support requirement, I ask you to take into consideration what the parties have been doing and what's actually in the best interest of the children. So that's how I'm going to leave it for. But I believe this is a full-blown contested custody. As I'm just let the judge make a decision as to what's best for the children. But I think the court shouldn't touch child support or the current visitation they're doing. But I'll leave it. I defer to the court.
All right, thank you, sir. Ms. Cusack.
I'm glad it reminds me when I'm muted because I always forget it. As far as I don't know, I've spoken with Ms. Lloyd. I don't know. She may have a different take on it than either of the two who just spoke, have indicated. I'm not quite sure where she stands on the issue of child support and retro, but we can allow her to address that later. My clients, I have 2 child clients. DJ is 7 and Denham is 5. I have a longer version and a shorter version, Judge. As far as what you need from opening, do you need just to know kind of in general what I'm
give me the long one. Let me hear the long one.
Okay, so Denham, basically DJ is 7 and he can talk my ear off. We can actually have a communication, and he talks to me quite a bit when we meet. Denham is a good speaker for someone who just turned 5 a couple weeks ago, but Denham kind of gets bored of me and wants to go do something else pretty frequently. So I don't have as much feedback from Denham as I do with DJ. I agree that the parties have been alternating visitation since they split up. They've been switching off, they've been switching every Tuesday. And there have been hiccups, but they also have been existing like that without the typical problems that other people have as far as snatching up kids. And they've been doing this without court order. I thought that we had a court order, but apparently we don't. I was going back through my files to try to see how we had addressed the issue of conservatorship, and I don't see a court order, a temporary court order for custody, even though we've been in court. So I think they've been kind of doing what they've been doing, and that's been alternating every week. DJ, the oldest child, is happy with the schedule. When I first met with him, I met with him in mom's home, and he was happy with the schedule, but then he kind of indicated maybe he didn't want to, back and forth so much, and he kind of seemed like he wanted to stay with mom. And then when I talked to him in dad's possession, basically that flipped. He said that he liked being with dad. And then since then, we really haven't talked about, we've talked about this schedule, and the only recommendations he has made is that, well, what if we do Wednesday instead of Tuesday? And there's not a real reason for that. He said something like, well, then I can stay at each house longer. And I had to explain to him, and he got it this time. I said, well, if you stay a day longer, then you're at the other parent's house, a day later. And he was like, oh, okay. So, but he seems happy with it. Each parent brings different skills to the table. So basically what I was requesting is joint managing. I think maybe it might be beneficial to have a primary. And if that's the case, looking at some of the other control issues I'll talk about later, I was leaning towards mom on that, but having a split possession schedule. And so where it's basically a true 50-50. Like I said, each parent has their own skill. Dad is super involved in athletics, and DJ is involved in soccer and all kinds of athletics. And then it's going to switch over to baseball and just the typical sports kid kind of thing. Both boys are involved in it, and he's really good with that. He wanted mom to be more involved in some of the sports activities, and so that's something that both parties have been working on. And then I think mom is very focused on school. There was an issue about whether DJ could go to a soccer game recently, and it was because he was behind on some of his projects. And I think Miss Lloyd felt that she was having to play catch up all the time on the education side of it. So I do think they each have their skill that they bring, and balance that they bring to the table. And so I think it kind of works out in the long run. As far as just to let you know that there have been allegations of domestic violence on both sides. I think that has settled, though. This was back when they were together. And Mr. Felton, they both basically pled or did deferred adjudication to some sort of family violence during while they were together. So that we'll have to look at that from a non-disclosure standpoint. I believe they've been switching off at school, so that really the split possession thing doesn't really present a problem where the family violence issue is concerned. Each party can talk about the family violence if they want to. I believe Ms. Lloyd would probably have some issues to talk about some medical issues that came up from one of those incidents. There was also an incident that was brought up recently about the boys and whether mom's boyfriend had hit DJ in the chest. So I talked to both of the boys about that, and I got kind of mixed signals from both of them. Denham said it was something about a towel, like I don't know if he got like popped with a towel or something like that. And I said, did it hurt? And he was like, no, and then he just I said, does he make you scared or worried, or did it make you cry? Did you, were you hurt? And he did not seem fazed. DJ made it seem like he actually kind of got popped in the chest, but they both say that the boyfriend plays with them and they like him too, so I don't think it's a danger situation. I think it's an issue of we just need to set boundaries on physical things like that. So if they're just playing, that's one thing, but if it's kind of a punishment, then that would be something that should be left to the parents, I think. The bottom line is no one was injured or really scared of him in that situation. So like I said, I don't think it rose to, it's something to keep on the radar, but I don't think it was something bad. I think basically we can look at this one of two ways. I think we can either look at this for the flaws that are in it, or we can look at it as kind of an ideal. They both bring things to the table. I think that dad has more resources than mom does, and I don't know if that's a good or a bad thing as far as a fact. He lives primarily with his parents, and it's kind of a good deal. You know, he's got the kids talk about Grandpa and Nene, and you know, Nene was in the kitchen cooking one day when I was talking to them, and so that can be a good thing. On the other hand, you have to kind of admire the fact that Miss Lloyd, who doesn't have all of that support, has been doing this essentially on her own. And so she's kind of provided some strength to this. Another thing I noticed when the boys were at Miss Lloyd's house is that they didn't have as much, like dad provides the tech stuff, like the boys were showing me all their video games, which you would like, Judge. They were showing me all the different video games that they had. But then when you look at mom's house, DJ went over and there was like a box, like a crate that had like files in it. And he pulled out a piece of paper and it had like facts about Texas. And it had, you know, like the Alamo and things like that. And he told me Texas facts while we sat there. Like I said, he and I can talk quite a bit. And so she's got these things in her house and in her system that are there for them to go find, and he found that on his own. Like she didn't say go show her this. I'll also state for the record, when I talk to the boys, there may be times when the parents are transitioning over, but when I really talk to them, the parents have to go into other rooms so that I can hear really what the kids want. So I really do feel that this is one of those situations. If the parents can learn from the small skirmishes that they have, I think it's something where it could be basically what they've been doing all this time.
All right then, folks, let's go ahead and get some testimony from everybody, and let's see how far this one gets. And Mr. Diamond, the retro, you're acting, the retro that you say was in play, is that just child support, or is that child support plus medical?
I believe it's just child support, Your Honor.
All right, well, let's get some testimony of what's going on, and let's figure out whether or not it's going to be, that's not even going to be appropriate at this time, and we'll figure it out also. So at this time, I'll ask both the parties, Mr. Felton and Ms. Lloyd, to unmute themselves, turn on their videos, and raise their right hands. Do both of you solemnly swear or affirm your testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Yes, sir.
Miss Lloyd, can you tell the court how long you guys have been, you and Mr. Felton have been doing this, the visitation you have right now?
Probably like 3 or 4 years.
Like in the 3 or 4 years that when it first started, can you tell the court how you guys basically got this visitation started?
Well, I was moving out of his parents' house and he stopped me from taking the boys. So that's how all of this really started.
Okay. How long did you guys live in his parents' house?
It was on and off pretty much throughout the whole relationship we were together.
Okay. So since the children were born, so on and off, you guys,
Maybe even before they were born.
okay. I'm just focusing on the children. So since the
Okay.
first child was born and the second child, where you guys mostly resided, were his parents' house before you separated?
Pretty much, yes, sir.
Okay. And that separation, do you remember the last time you actually left for good?
Sometime May, let me see, I think Denham already had hit a year. So it was like mid-May of 2021.
Okay. So since 2021, you guys been doing, is that when you started this schedule?
Yes, it's when I was leaving their house, sir. He stopped me from taking my boys. Yes, sir.
Okay. And what is not working with the schedule right now?
I don't know.
No, I mean, what are you asking the court for?
I don't know. I think I'd rather do a reset because I think I need to lawyer up myself at this point.
You know, I will let you make a ruling, but I'm not getting the response I'm asking for.
I understand.
Yeah, all right, this is not a criminal matter, but Mr. As soon as they ask me they want a lawyer, I give them a lawyer. I let them get a lawyer. Here's the
Okay,
deal,
Your
man.
Honor.
Here's the deal, man. This is a last minute deal. We've been doing this a long time, and I wish you had done this earlier. But the bottom
I
line
mean,
is,
yeah.
ma'am,
I mean, y'all
stop,
not
stop, stop,
seeing.
stop,
It's
stop,
like
stop, stop,
y'all not
ma'am,
seeing
stop,
the
stop,
facts.
ma'am, stop. Here's the deal, ma'am. I don't need to know the reason. I just need to know you're telling me you want the opportunity to talk with a lawyer. I'm going to give you that opportunity, no ifs, ands, or buts. Okay, that's all I'm saying, ma'am. So but since we've been doing this so long, I don't want to stretch this out another 3, 4, 5, 6 months. I want to give you the time frame to go talk to a lawyer, see whether or not you're going to retain a lawyer. They're expensive, some thousands of dollars up front, maybe several $100s an hour. But you now asked the court for it, so I'm going to grant that, ma'am, because again, the way this system sets up, if I made a decision today, you would still have the opportunity to go out and hire a lawyer and let the district judge do it all over again. So I want to do this one time, okay, and get this thing
Okay,
set
thank
up.
you.
So I'm going to go ahead and I want to set this for. I want to be reasonable. So I usually give parties at least somewhere between 4 to 5 weeks to go ahead and talk to a lawyer, and then figure out whether or not they can afford the lawyer or not. I'm looking at keeping everything as is. Y'all been doing the week on, week off. We're going to keep that as is, but I'll give the mom the opportunity to see counsel. And ma'am, I want to set this for a pretrial to see whether or not you've been able to retain counsel. And I'm going to, and unfortunately, Belinda's not here, and Miss Walker's not here. Mr. Diamond, do you have a date that shows Miss Cusack being here anytime in the okay, we're already at the end of March, so anytime after the 1st of May. She's already going to be here, and now we'll see about the counsel for Mr. Felton to see if he can make that schedule. Otherwise, I'll just start looking at time frames and we'll figure one out.
So, Your Honor, there's May the 1st, but that's a general docket. I would request a special setting.
No, I'm saying this is a pretrial. I'm not looking for it. I want to see if mom's going to hire a lawyer or not, and we should know by then. So one way or the other. So I'm giving her a month to do that. So yeah,
So, Your Honor, yes, sir. So, Your Honor, May the 1st, Miss Cusack is here. That's a Zoom docket, and then she's also set on May the 21st, but that's in person in Belton.
All right then. All right then. So May the 1st is a Thursday. And obviously we can do another time. Mr. And again, I'm sorry about asking your last name, sir. Miss Cusack's already going to be here on the 1st of May. That's a general docket. Only thing I'm looking for is to see whether mom has retained counsel. And then if the mom has retained counsel at that pretrial, I'm going to set us up for another, I'm going to do a scheduling order one way or the other. So if she comes in with counsel, I'm going to do a scheduling order where we can get this thing done ASAP and we'll get that done on that date. Or if mom doesn't have a lawyer, then obviously we can just go ahead and set this matter and for final hearing one way or the other. So can you make the 1st of May work, sir, or do I need to look at another time or day?
No, you're good. May 1st works for me.
All right, then. Thank you. All right, Ms. Lloyd, I'm going to go ahead and look at resetting this matter for a pretrial to give you the opportunity to go speak with counsel and possibly retain legal counsel. And I'm looking at resetting this matter for that pretrial at 9 a.m. And I'm going to use the same Zoom code as this. I'm going to keep you guys separate and apart from the regular docket. But there's a docket call. It takes about an hour to go through all that information that we give out initially. What I'm going to go ahead and do is move this code, same code we have today, to 10:15 a.m. So and that way everybody just needs to log in at 10:15, and then we'll get an update on your circumstances, ma'am. And then we'll figure out if you have a lawyer, we'll work with we'll work with all the lawyers involved here, and we'll come out with what's called a scheduling plan, which means we'll set up deadlines for where everything has to be done, including when the final hearing is going to be. If you do not have counsel, then ma'am, then I'm probably looking at just going ahead and setting this for a final hearing. as soon as practical, and practical in most of these circumstances, at best is usually within the 30 days of that. So sometime by the end of May, we can probably wrap this up. If not by the end of May, by that first week in June. So, but the bottom line is, ma'am, I'm gonna give you that right to go talk to a lawyer, because again, that's your right. And if you think you need to seek legal counsel, well, I'm going to allow you to set that up, ma'am. So at this time, ma'am, do you have any questions?
He's not in here.
Did we lose her? Oh, great. Okay. I didn't hear a ding. Usually when somebody accidentally gets out, it dings.
We can send a notice of hearing, Your Honor.
Okay. She may still be here. You know, sometimes that happens. The signal's just so bad that they're still in here, but they can't broadcast. They can receive. So, but right now, I think she's just plain gone. All right, then. But again, that's what I hope she heard enough of that. But I'll let Mr. Diamond, when you put in the reset order, just put in there that this was at the request of the Miss Lloyd, and that she wanted the opportunity to seek counsel. I'm giving her that opportunity, as reset for 10:15 a.m. on the 1st of May, this same docket. And it's set as a pre-trial to get an update on whether or not she's being legally represented. All right.
Got it, Your Honor.
Yes, ma'am.
May I add one thing to add in that reset order? Could I if the court could make I guess order the parties not to talk about the litigation with the kids. I don't want them, hounding.
I'm going to go ahead and do it. I'll go ahead. All right, I'm gonna keep everything else. Continue on your week on, week off. I'm gonna make that part of the reset order, and I want the state to go ahead and include the standing order from Bell County. That's all in there, okay?
Okay, thank you, Judge. I just don't want.
Bell County has a standing order where parents. Huh?
I just don't want them
sorry?
questioning the boys about the allegation that was brought up.
All right, here's the deal, folks. Do not mention these matters that will come before the court today to either of the two children. Understood, sir? Mr. Felton, you understand? Yeah, let's keep let's let them be little boys, and we'll be the grown-ups, okay? All right. And Ms. Kuzak, be sure to send that information on to Ms. Lloyd too, okay?
Thank you, Judge. That's what I wanted to do.
Mr. Wellway, I'm going to go ahead and put in the standing order. When this thing was originally filed, we didn't include the standing order, but now by the new district presiding judge, we do. So I'll have this attach a copy of the Bell County standing order also, as far as to give the both parties some guidelines on what they can and cannot do. Okay. I'm sorry, sir. I couldn't hear you.
I was saying, all right. Thank you, Your Honor.
Okay, thank you. Again, my apologies, folks. I didn't see that coming. I didn't, so. But once they ask for a lawyer, it just makes it so much easier for us to get it set up. Let them get one, or let them go out and find out. What do you mean? I need a $10,000 retainer. So yeah, it is what it is. So.
Thank you, Your Honor, and I like your policy, by the way. So.
Oh yeah,
they ask for it, they go.
Yeah, it's just like with your kids. You give them some room, let them figure things out, and most times they'll figure it out right, and they'll be their idea. There you go. All right, Mr. Diamond, anything else?
Nothing further, Your Honor.
Ms. Cusack?
No, Your Honor. Thank you.
All right. Thank y'all all very much again. My apologies. Yeah. I'm sorry. I asked you first, so I'll say, well, counsel for Mr. Felton. Anything else, sir?
Thank you. No, I'm good. Just needed to know if I'm excused.
Zoom code over immediately. Sorry about that, Mr. Felton. You can talk to your lawyer. But again, sir, that's when people start asking for the opportunity to have legal rep, you let them go. You let them go find out for themselves whether or not they want to try to do that or not. But anyway, we'll get this one done and try to get you folks out of here as fast as we can next time around. Anyway, we're off the record, and I will go ahead and let y'all go. Thank you.
All right. Thank you, Your Honor.
Yeah, thank you. Yes, sir.
Thank you, Judge.
Thank you, Your Honor.
Yeah.
I don't understand, how did